This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
It's written notes are
not written notes. I have not just little explanatory, nothing else. Now, kindly turn to the state alert, Article 162. That Article 162 is the state's executive power. Extent of executive power of state, subject to the provisions of this constitution. The executive power of a state shall extend to the matters with respect of which the legislature of the state has power to make laws, provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. Therefore, the executive power, which they say that we have executive power, cannot rise above the constitution. And the public employment is governed by Article 14 and 16. This is now a settled position which is a part of the fundamental right. Therefore, whatever executive power you have, you can exercise in the field where you have power to make laws. And in this respect, my lord, you have already made law for recruitment of teachers. Therefore, you cannot have any other power beyond the laws which you have made in exercise of the Article 162. And vis-a-vis this, just I take the liberty to point out, Lordship, the stand of the state. Kindly takes up once again the affidavit of the state. It's affidavit of state by the first affidavit, 28th of November, 2022. There is a fantastic way of claiming. Kindly come to subparagraph F. I just not place the important pleading or submission. The fourth line from the bottom of the same paragraph. Hence, it cannot be said that the teachers of a recognized aided institution are not in public employment. In fact, they are supporting in public employment. They have a government Article 14-16. Then, accordingly, the recruitment and selection of the teachers falls within the larger framework of the Constitution and cannot be limited to statutory framework alone. And the larger framework of Constitution is only Article 162. And that Article 162 empowers you to work subject to the provisions of the Constitution. This is no power beyond the Constitution can be exercised. Therefore, Lord, they themselves have admitted that this has been done beyond the Constitution. Now, this is the constitutional position. Now, let us see how these issues.
They are suggesting that it is within the larger framework of Constitution. So, they are required to trace their such power within the Constitution.
Yes.
Has it been explained anywhere in this?
Nowhere. No, there's no other power except Article 162.
You may not be knowing.
I always accept, my lord. We live to learn. I cannot say that. But so far, so my knowledge, my lord, goes, Article 162 is only authority under the Constitution to exercise the executive power in the field which under that seventh schedule, second list, you can exercise. And in exercise of such power, you have already made the rules for recruitment. Therefore, you have no other power. Now, just for my interest, I will just refer to your lordship. Since this division bench has decided and the Supreme Court has upheld, few paragraphs relating to this supernumerary post.
Give me the paragraph number.
Yes, I would just, I'm really tempted to read paragraph 350, 351, 352, 350, 34, 356, 357 and 350, up to 359 rather. I am tempted to make this, read this paragraph which has some philosophical connection to the society.
360
and 360 also, yes. Now, the educational institutions have been admired, accorded special place in the society, and have been ring-fenced against the ills that may befall the society. Civilizations have made such attempts so that the future generation develops in an environment conducive for attaining the dreams of an individual student and caters to the holistic development of the student. Educational institutions are expected to produce better and evolved citizens who would be in a position to contribute to the society, nation, and to the mankind. Parents put their wards into educational institutions with the expectation that such educational institution imparts a level of education so as to assist the wards to develop into a better human being. Human beings are in control of any educational institution as in other institutions. If the teacher and the non-teaching staff of such educational institutions or even a portion thereof obtains appointments fraudulently, such teacher or non-teaching staff immediately forfeits his integrity, honesty, and his ability to impart wholesome education to a child in such an educational institutions. An educational institution must be protected against such elements attempting to percolate, permeate into it. It is therefore imperative and in the beneficial interest of society that such elements are removed from an educational institution. Then important. SSC has filed Can 2 such and such you have placed before a lordship, seeking permission for creation of supernumerary post for the illegal appointees. When objected to by the writ petitioner, SSC had sought to withdraw such applications. Learned single judge had declined the request for withdrawal by order dated so and so. A special writ petition had been preferred where an order dated November 25, 2020 had been passed. In the two applications noted above, the learned single judge had directed CBI to undertake investigation in respect of the creation of supernumerary post. Division bench had refused to stay such directions. Supreme Court had, by order dated November 25, stayed such direction. Stay granted by the Supreme Court in November 25, 2022 was against the interim order passed in the pending writ petitions. Lest it be contended that we have not directed measures to be taken in respect of creation of the supernumerary post on final hearing of the writ petitions and the appeals, we deem it appropriate to pass necessary directions with regard thereto also. Investigation by CBI with regard to the creation of supernumerary post is imperative to bring to light the nature and extent of the scam and persons that are involved therein. It is shocking that at the level of the cabinet of the state government, decision is taken to protect employment obtained fraudulently in a selection process conducted by SSC for state-funded schools, knowing fully well that such appointments were obtained beyond the panel and after the expiry of the panel at the bare minimum. But this is important for our purpose now. The enormity of such wrongdoing is accentuated by the fact that the illegal appointments are sought to be confirmed in educational institutions. Persons involved in such decision-making process therefore have exposed children to persons who obtain their employment through fraudulent means. Unless there is a deep and pervasive connection between the persons perpetuating the fraud and the beneficiaries thereof with persons involved in the decision-making process, such course of action in resolving to create supernumerary posts to protect illegal appointments is inconceivable. Moreover, each of the persons involved acted in violation of Article 14 and 16 of the Constitution of India. Whether such violations have resulted in criminal liability should be investigated into. Because criminal liability portion is stated by the Supreme Court, but Article 14, 16 has been upheld. Therefore, this supernumerary creation was also a part of the division bench judgment, which deals with the violation of Article 14, 16, which has been upheld by the Supreme Court. The next paragraph. Since at least a portion of the beneficiaries of the scam, that is to say that some of the persons who were appointed beyond the panel and after expiry of the panel and appointees submitting blank OMR sheets stands identified, it would be appropriate to direct such persons to return the benefits. I am not troubling my lot with that. Then, exception. During the pendency of these proceedings at para 360, Learned Single Judge had taken note of the plight of one candidate, namely Shoma Das, and directed registration of a writ petition number with regard thereto. Shoma Das has subsequently filed in which an order dated April 18 was passed by a learned judge. There the learned judge had taken note of the medical condition of Shoma Das and requested the state government to consider providing her an employment purely on humanitarian grounds. In course of hearing of the matters before us, it has been submitted that the court should make an exception so far Shoma Das is concerned, since an appointment was purely on humanitarian grounds, which has been upheld by the Supreme Court also. We have considered the order dated so-and-so and find that request for consideration of appointment of Shoma Das was made purely on humanitarian grounds due to medical conditions of such person. Mrs. Shoma Das had been granted appointment by the state government purely on humanitarian grounds. Consequently, we propose not to disturb the appointment as state had granted her appointments on humanitarian grounds. She will stand outside the directions issued hereafter. On this discussion, ultimately, the Honorable Court was pleased to set aside the appointment. And the cabinet memo is basically based on Shoma Das's case.
No, so far the directions or to what extent the division bench considered this creation of the supernumerary post?
To the extent of Article 1416.
No, so far the affidavit or the application filed by direction based on that.
Yes, yes.
Whether the what is the subject matter of challenge in the writ petition? Somewhere around it has been covered by.
But in my writ petition here,
whatever the challenge,
our challenge is without
supernumerary.
No. Entire selection.
No, so far the supernumerary. Your challenge to the extent of 19th May 2022 notice, creation of physical work. Whether that notice, 19th May notice 2022, has anyway the division bench has.
No. Division bench did not really go into the nitty-gritties of 19th May notification. Division bench while found that supernumerary posts are created to accommodate the illegal appointees on the basis of the.
You have read somewhere, this is beyond the life of panel?
Yes. But this is here also, kindly I was placing paragraph
147 is not a legal work. No appointment can be made after expiry of the ban.
Yes, paragraph 355. Paragraph 355, it says, my lord, that the appointments were obtained beyond the panel and after expiry of the panel at the bare minimum. Here also, my lord, the appointments ought to be given not after expiry of the panel. And that expiry, my lord, is stated to be violation of Article 14 and 16.
Where?
My lord, next paragraph 357.
357.
Moreover, each of the persons involved acted in violation of Article 14 and 16 of the Constitution of India. Whether the violations resulted in criminal liability, but I am not troubling, that was said. Therefore, not that apart, the other portion of finding that this violation of Article 14, 16 is upheld by the Supreme Court. Now, I will just place the order of the Supreme Court one second now. It is third
April, 8th April.
First order. যেখানে পুরো সেটা সাইড করে দিল। Now the Supreme Court judgment, my lord.
Yes.
3rd April, where the court finds. Can you come to paragraph 46? Anyway, he wants me to read 45. It's not necessary 46 because Article 14, 16. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violation and illegalities which violated Article 14 and 16 of the Constitution. As such, all the appointments are cancelled. But this is a conclusive finding of the Honorable Supreme Court that violation of Article 14, whether you are found to be tainted or not, is immaterial. Here also, my lord, this notification itself is not a violation of Article 14, 16. And when on the affidavit they say we have executive power under the Constitution. Now, I may just point out once again, I have pointed out, Lordship, the affidavit of state. Affidavit of state, my lord, that paragraph is very interestingly drafted with all authority.
Election process held in 2016.
My lord.
A part of which has been found to be wholly polluted. How can the other part be so?
How can it revive?
Or like Ganges?
Yeah, that is not. How can it stay even for a single day? But if
it is your
but if the supernumerary creation of post, they say subject to the pending of the writ petitions. They do not say that subject to the pending of the writ petition before Lordship, which was challenged after the supernumerary posts were created. But they say that all these petitions are pending before the High Court. I will show me that this state's stand. First, Justice Chidambaram order first. Chidambaram. Chandrachud. The state stand was that the supernumerary post, though created, no appointment was given because of pendency of writ petitions. Therefore, they also knew. Joshua ke dawa copy. Diyecho.
আরেকটা দিয়ে দেবো কি স্যার এটা দিন এটা মার্ক করা আছে
This is the first day order before the Supreme Court when state moved and got a stay. It is 7th main order.
Paragraph 22. Paragraph 22.
Done.
Yes, sir. We WP number first of all. Ending 22.
Yes, may I kindly come to note paragraph 21. On May 1922, the government of West Bengal issued an order creating 6,000 so supernumerary posts for teachers, non-teaching staff for absorbing the waitlisted candidates and directed that the appointment letters to such waitlisted candidates shall be issued in terms of the recommendation SSC subject to the outcome of the pending litigation before the High Court.
This writ petition.
Yes.
All these three writ petitions.
All these petitions.
5 writ petitions. All these 250 to 256 are before me.
Hey, কি বলছেন Josh?
All these 250 to 256 are before me.
WP number
এই রিপিটিশন গুলো তিনটে আছে আর তিনটে কোথায়
দুটো এখন অ্যাসাইন হয়নি এবং এইটা স্যার আপনি পড়ে দেখেন এটা স্টেট বলেছিল যে এইগুলো আজকে লিস্টে তিনটে আছে
three matters are pending before your lordship and other three I am told not yet assigned. বাদ দাও যা আছে আছে
তিনটে আছে ওয়ার্ক ফিজিক্যাল বোথ আছে
স্যার এইটাই নাম্বার হলো 25,056 এটা একটাই আমার হাইফেনটা হবে না
I am also outdated. The writ petition number is 250256 not hyphen.
Oh, আচ্ছা আচ্ছা আচ্ছা
আমাদের এটা নম্বর কত
250
yes this is
250 not 25056
yes.
1 2 is excess
that the hyphen is
and 2 is also excess
2 is also
25056
yes
now therefore this is the stand. I am just reading once again Lord. During the course of hearing, this court has been informed that petitions under Article 226, this petition has been instituted before the High Court to challenge the order of the government creating the supernumerary post to accommodate the waitlist candidates. By an interim order, the government order creating the post have been stayed. Now, but this stay was not stayed by the Supreme Court. Since I had the privilege to...
Was it prayed for?
Because they prayed for that severe investigation against the state for creating supernumerary posts. Please stay that.
CBI investigation. But since the stay is already there,
no argument, because that was the sheet anchor of the defense. Since no appointment could have been given because of stay, therefore there is no criminality.
No, the background, I don't know whether at that point of time you were there or not.
No, I was there physically. That's my difficulty.
No, not that. This matter. In this matter, two things proceeded parallelly. The one is this challenge. Simultaneously, the direction of the coordinate bench to go into the CBI inquiry as to the decision of that. That traveled through division bench to an SLP before the Supreme Court. Supreme Court state division bench has recorded. That SLC is pending. At that point of time, this challenge was shown. And Mr. Gopal Mukherjee.
Yes, he said that this issue might be...
No, I must say, he was a man of stature. When I put him this question, that if you can assure this court that this challenge
would not
or the power of state to create such post is under challenge here, this issue will not incidentally would be raised in that SLP. He then took specific instruction of his counterpart in the Supreme Court, said no, that assurance I cannot be given. Matter was time to time deferred.
Yes.
Even the state took a stand that no, we are not going to give any appointment now.
That's clear.
So why the matter was deferred?
Because of that.
Pending issues are there. In the meantime, division bench.
And then my lord directed the state to file an affidavit specifically stating that whether this will clash with the Supreme Court determination.
They refused to.
Therefore, this stay by this court in respect of appointment vis-a-vis supernumerary post was their defense
to get the stay of the
criminal investigation.
কুমার দাসের এক্সেপশন সুপ্রিম কোর্ট দিয়ে ওটা একটু দেখিয়ে দেবেন কেন? প্যারাগ্রাফ 47, it only restricted to Kumar Das, entire thing is back.
সে তো বলেছি অলরেডি
Supreme Court
I have already probably I'm repeating being
prompted by
poked by, I don't say prompted. Now the Supreme Court dealt with the Shomadas issue, paragraph 48.
of 3rd April.
Yes, that's similar to the base order.
Yes, lastly,
we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment held that the appointee Shomada shall be allowed to continue on humanitarian grounds. That's important. While we will not interfere with this finding, we make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. Therefore, many, don't take it otherwise, many dramas were created in the court of the Supreme Court. Certainly, my lord, some visually disabled persons, they were brought in court to argue, in spite of their senior counsel having argued. The Honorable Chief Justice heard them and said, I'm not going to give you benefit. And that's the finding at page 48. Shomadash is exceptional. She was suffering from cancer. The court not felt if some concession can be given. Therefore, that cannot be, my lord, a ground. That's why I say that will really contradict the main finding of rule of law. That is paragraph 48. And rule of law is article 1416. And the state in its affidavit firmly says that we have our administrative power. I had pointed out to your lordship, note, I again point out, my lord, that this is the stand of the state at page 8 of their affidavit, subparagraph F. 28 November. দেখালাম তো এই মাত্র ও নামিয়ে নিয়েছেন
আচ্ছা আমার ইয়ে যা একটা কোথাও ওভাররুল করলাম আছে হাতের কাছে
subparagraph F. E. You could have placed, I am not troubling, my lord. They say the validity period has expired is an irrelevant consideration for creation of supernumerary post. This is where, yes, that is subparagraph E, last line. Subparagraph E starts at page 7, continues to page 8. State, having made statutory rule, now says that is immaterial consideration. Then it is stated that subparagraph F is very interesting. This is source, they say. Last 3 lines. Accordingly, the recruitment and selection of the teachers falls within the larger framework of the Constitution and cannot be limited to statutory framework alone. This piece could have been a new addition to the constitutional jurisprudence. Statute maker says that the statutory empowerment is immaterial. I have higher constitutional authority. What is this? Article 162. What the Article 162 says? Subject to provisions of the Constitution. You can take a decision in the field which empowers you to make law. And having made law, you take a stand saying that this is immaterial.
Is it lack of understanding or to save a situation?
To create more chaos in the society, not to save a situation. Lordship can take judicial notice of the fact that this has created huge chaos in the society. I do not travel beyond this. But this has, everybody must have taken note of this fact.
Who is at the receiving end?
Bikash Ranjan Bhattacharya. Why did he raise this issue before the court?
Or
Why did he argue that the entire panel should be set aside? He should have argued that the corruption should be prevailed.
So ultimately the candidates,
ultimately they are misguided people. Anyway, I restrained myself, my lord, from making this statement. Therefore, the stand that we have a constitutional power, my lord, belies the specific words mentioned in the Article 162. There is no other power by which state can exercise executive power to do something. Now, the next question will be whether the judicial review is permissible. That point has been mentioned and taken by the court to judicially scrutinize the order passed by a cabinet. It means that if the cabinet tomorrow says that I let annul all the terrorists who are imprisoned free, that decision cannot be reviewed. That's the stand, but that's not the law. I will take a lordship to the law.
just
প্যারাটা ঠিক আছে, প্যারা 37 ওটা 22টা বলেন, প্যারা 37 স্পেসিফিকলি বলা আছে যে ওরা প্যারা 37 ওই দিন অর্ডার
যখন বলি তখন বলা না কেন?
আমরা তো বললাম যে তোমার ফ্রন্ট করে
ঠিক আছে,
স্পেসিফিকলি বললাম।
বিপি সিঙ্গল
BPC 2010 666 BPC
কি আছে কি বলে?
did you cite that 2006 to SCC, the Vaghela's judgment?
Yes, not in that matter.
In some of the Article 16, which finds place in the Part 3 of the Constitution relating to a fundamental right, provides that there shall be equality of opportunity of all citizens in the matter relating to employment or appointment in any office under the state. The main object of Article 16 is to create a constitutional right to equality of opportunity and employment in the public offices. The word employment or appointment cover not merely the initial appointment but also other attributes of service like such and such.
But it was cited by me in Darjeeling matter.
Yes, you had cited. But I have used it in another matter.
There is all
in Arjigor matter I have used it.
Similar judgments are only common in both matters.
So Article 14 and 16 ultimately has to be adhered to.
But it's a fundamental right. No one has any authority to act in breach of fundamental.
162 does not give that much of power.
It starts saying subject to provisions. The constitution makers knew that may at some point of time some people may come to power and they say we are the monarch, therefore we can do whatever we like. And Ambedkar said, don't forget, we have a written constitution, we have a limited government. These issues were discussed during the constitutional debate. We have a written constitution and this is a limited government. No one has authority to act beyond constitution. Now, my lord, the heated debate is going on. Lordship is aware. The Supreme Court has said even the governor and the president doesn't have the ultimate discretion to sit over the decision. They have to give a decision within a certain time. Normally in Madras governor matter, the president, my lord, has been pleased to, my lord, make a reference Supreme Court will reject it, I am sure.
Here, even the legislature has framed a law, has legislated a law,
The field is occupied.
occupied field. Now, what is he saying? That it should fall under larger framework of constitution.
not know.
So he is given by the
This statute.
legislative field goes banks on the constitutional provision. That is under Article 62. 62 limits the power subject to the other provisions. So now you will be citing judgments now?
Yes, I will cite.
Can we continue when?
Whatever time your lordship allows me.
Because I don't know who is for the state now.
Advocate General was there.
Very well, because this week it will not be possible for me to accommodate. Let me come back with a fresh mind.
Where are you going?
Andaman circuit, then I will take. Let some fresh air come.
Anyway, subject to court's convenience, lordship.
Because I know that this will be an interruption on your argument, but I need to close down it very quickly. So what about, you would like to cite some judgments? Now this is...
The facts are now, so far I am concerned, clear. I shall not give authorities.
You have given an outline of it in these 2 pages.
Not today's argument. Today's argument I shall give next day. This is my first day argument.
You make it and give it to me so that I can go through it. And we can avoid repetition.
No repetition. এরপর আরেকটা পাতা আজকেটা দিয়ে দিই।
একবার শুধু প্যারা থাকছে একবার দেখে দিন।
Yes.
একবার প্যারা থাকছে। একবার।
Please, Milan.
But my juniors again prompts me. I am just in paragraph 37 of first day's order. The court has been Supreme Court pleased to record. Paragraph 37. I am reading out. Mr. Rakesh Dwivedi with Mr. Neeraj Kishan Kaul, senior counsel, appearing on behalf of the state of West Bengal.
7 July order, first day order, 7 July.
3rd April order.
7 July.
7 July.
7 July naki.
That is day, first day.
2025?
No, that is from the June.
7 May. July and May.
He is perhaps reading that portion where they submitted to the Honorable Supreme Court that no appointment is going to be made.
Pending writ petition.
7th May.
7th May.
Yes.
Pending writ petition.
Yes, I have.
That no appointment, this council submitted appearing for the state that no appointment whatsoever has been made in pursuance of the order of the state government dated 1922, which in any event forms the subject matter of a pending writ petition.
Where you are from?
The paragraph 37 of the order.
This is order dated
7th of May, first order.
But the SSC affidavit has already said that recommendation has already been made.
Yes. The recommendation was made, but not appointment.
No appointment.
The recommendation appointments are different.
No appointment given. Therefore.
No,
so yes.
It is my as a.
What? Tell me. What is? Tell me what you want.
Kindly do not
tell me,
I am trying to emphasize that, Milord, one order is there which I will invite my senior Milord to distinguish, because the challenge thrown to this entire process, at some point of time, Milord, he had the occasion to represent us in 2019, and the challenge failed. I am handing over a copy.
At a time,
at the time, the issue is I hand over a copy of the order. Milord, when he is going to make his submissions, I will request, Milord, because there is a complete controversy, Milord, going on, inter se the applicants, because it is an
No, I understand. He appeared once for
not only he, they visited the place.
Oh.
Those things are there.
Very well, he will answer to that. Raise it in
We
reply.
still say, we have said that the appointment
So
should
the
be
thing is,
made
Mr. Bhattacharya
following
had the
the-
occasion to appear for us, for some of us, not all of us.
not to seek illegal appointments.
Yes, to question the appointment process.
Yes.
15 September.
Okay, now.
15 September. Morning. From the morning.
For the morning or the whole day? Philosophically.
15 September.
Wait a minute.